Welcome to the Eagle Eye Solutions Network. New York City eviction presentation for mom and pop homeowners. This online video is designed for mom and pop landlords in New York City. The purpose is to educate them on the New York City eviction landscape and how to navigate it. This short video will be in 3 segments. 1. Introduction to Eagle Eye Solutions Network. 2. Explore the changes in the housing court laws. 3. What is Senate Bill S3082? Hopefully by watching this presentation, you will be better informed on the New York City evictions process. If you have never evicted a tenant before and thought the process was easy, then this video should provide you with vital knowledge. It won't teach you everything in one sitting, but it is our hope you will be enlightened to the momentous battle facing homeowners such as yourself. An informed landlord is a prepared landlord. Introduction to Eagle Eye Solutions Network. Eagle Eye Solutions Network is a property protection service company that cater to mom and pop homeowners in the 5 boroughs of New York City. We provide all the resources you need from basement to roof. The solutions we provide enables homeowners to deal with the major issues of owning a home. Issues such as understanding the eviction process, refinancing, foreclosure rescue. We equip and empower homeowners with the knowledge they need to maintain and keep their homes. Our vision: to develop a movement of educated homeowners in NYC. Mission: helping you protect your American dream. Objectives: to create a network of mom and pop homeowners, to unite and have one voice, to push back and lobby for fair protection under the law. To provide homeowners and property managers with a one-stop eviction service center that offers the finest, most efficient service possible at an affordable cost. Our network consists of licensed and bonded process servers, real estate brokers, contractors, handyman, paralegals, and attorneys to assist your every need. We know every homeowner's situation is different and unique, so we provide personalized service package to suit your needs. Look, it's simple. There are several resources put in place for your tenants. Resources such as My Rights as a Tenant, NYC.Government, TenantNet, Legal Aid Society, 311 Hotline, launched back on March 9, 2003. Many may have forgotten that one of the primary functions of 311 was for tenants with heat complaints. The New York City Rent Guidelines Board, RGB, HUD, New York City Housing Authority, NYCHAA, New York Public Assistance Programs, HOA DSS Cash Assistance, Section 8, Pro Bono Attorneys. And this is just to name a few. Big landlords have attorneys, tenants have Albany, the City Council, and a favorable court system. The big question is, what resources do mom and pop homeowners have in place to help them? The answer is, become a member of Eagle Eye Solutions Network and join the community of homeowners just like you. No longer will you be left to fend for yourself. Hoping to find a competent lawyer that knows the rules and regulations of the L&T court. In a moment, I will unveil the new weapon in the arsenal of tenant protection. Senate Bill S6458. The Housing Stability and Tenant Protection Act.
Let me start by saying, I am not an attorney. Nothing I say in this video should be construed as legal advice. This information is intended for educational purposes only. Before making a legal or financial decisions, you should always consult a qualified attorney. If you need the advice of an attorney, we can provide one for you. Again, the views expressed in this video are my own and do not necessarily reflect those of any law firm or any other business partners. So now that I got that out of the way, let's get to the reason why you are here. As of January 14, 2022, the New York State moratorium was lifted. Now you want to move forward with the eviction of your tenant. But before we go forward, let's backtrack a bit. Let's go back to June 14, 2019, when Governor Cuomo signed into law Senate Bill S6458, the statewide Housing Stability and Tenant Protection Act. This was a 74-page piece of legislation that radically changed the New York State housing court laws and procedures. Now, there are changes to the laws that governs rent stabilized and rent-controlled buildings. I will go into those later. Right now, let's focus on the changes that affect mom and pop just like you. I consider mom and pop landlords to be any homeowner with buildings that have 5 units or less. First things first, let me say this: the new laws and procedures as of June 14, 2019, does not favor you, the landlord. It is intended to make the process longer for eviction and for non-payment. Example 1. Prior to June 14, 2019, to start an eviction holdover proceeding, you only needed to serve a 30-day notice. Now, with the new law in place, if your tenant lived with you for less than 1 year, you serve a 30 days notice. If your tenant lived with you for more than 1 year but less than 2 years, you serve that tenant a 60 days notice. If your tenant lived with you 2 years or more, a 90 days notice must be served. Example 2. Prior to June 14, 2019, to start non-payment proceedings, you only needed to serve a 3-day notice. Once the 3-day notice expired, you could then file your case in the court. Now, with the new law in place, if the rent is due on the 1st of the month, landlord now must wait 5 days before you can do anything. On the 5th day, landlord now must certified mail and notice to the tenant letting them know that their rent is past due, and the amount owed. Without this step, your case is over before it starts. Next, landlord must serve the tenant with a 14 days notice. This used to be the 3 days notice. Let's take a moment and let this digest. Ladies and gentlemen, mom and pop, make no mistakes about it, this is a tenant-friendly court. The courts are not here to make the process of getting rid of your tenant easy. These new procedures are intended to have you keep the tenant as long as possible. You would be ill-advised to think or expect the Nyc-LNT court to advocate on your behalf. The court is not there to be your bodyguard or to hold your hand through the process. If you are having problems with your tenants, then Eagle Eye is your solution. Eagle Eye Solutions Network is your homeowner advocate service. Eagle Eye is the only company of its kind that specializes in helping mom and pop homeowners. We customize our services to suit our clients' every needs. A list of services we provide: eviction service, foreclosure rescue, rent collection, property management, home improvement. If you are looking to sell, we have a broker for you. Our staff consists of licensed and bonded process servers, real estate brokers, paralegals, attorneys, licensed contractors, handymen. All here to assist your every need. Let's take a look into another major change. Let's look at discretionary stay. Discretionary stay is a period of time allotted by the judge to a tenant that he considers to have extreme hardship. Under the old law, the judge had 6 months of discretionary stay. Now, under the new law, the judge now has 1 year, yes. You heard right, up to a full year if a tenant can show good cause of hardship. Again, previously this used to be limited to just 6 months, but under the new law, a tenant can now obtain a stay of up to a year. Reasons a tenant can show in order to receive this discretionary stay. 1. Tenant is unable to secure similar premises in the neighborhood despite reasonable efforts. 2. Tenant can obtain this discretionary stay if they can show moving will cause extreme hardship. Examples of extreme hardship include tenant is elderly and lived on the property for more than 10 years, tenants is disabled or have a serious illness, tenants have a young child that is enrolled in school in the neighborhood. 3. The judge will take into consideration extenuating life circumstances, which may cause hardship to tenant or the tenant's family. Tenant must be able to find similar apartment for similar price when relocating to ensure quality of life. 4. This should be a fair and unbiased view by the judge. His decision should also factor whether there is hardship on the side of the landlord. Let me take a moment right now and say, if you are looking to evict your tenant or just looking to collect back rent, you need a knowledgeable team that knows the system, working for you. Try to do it on your own or looking for the courts to help you is like asking the police officer that just gave you a ticket for pointers to win the case. Let's look at some more other changes under the new law. Notice requirements. If you decide to not renew the lease of your current tenant, depending on how long your tenant has been living with you, there are significant changes there too. Similar to the eviction notice. If your tenant has a weekly tendency, then a 30 days notice must be given for rent increase or notice to vacate. If your tenant lived with you for more than 1 year but less than 2 years, then a 60 days notice must be given for rent increase or notice to vacate, and, if your tenant lived with you for more than 2 years, then a 90 days notice must be given for rent increase or notice to vacate. When it comes to rent increase, the maximum amount you can now increase the rent on your tenant is $50 or 5% of the monthly rent, whichever is less. One of the services we provided in the past was background checks. We would access the court records for information on a potential tenant eviction record. Under the new law, this is now prohibited. The courts will no longer provide any eviction information to any third-party servicers. This means that when you do a background check on a tenant, you're not going to see any prior evictions on that report, even if that tenant has prior evictions. It is now prohibited for a landlord to deny someone with prior eviction from renting their apartment. If a landlord violates this new provision, he will now be subjected to civil penalties of $500 to $1,000 per violation. Let's come up for some air, shall we? If you are faced with foreclosure, there is provisions in place to help you. If your tenant owes you for back rent due to COVID-19, there is still ERAP money out there for you. 1 year back rent plus 3 months. Ladies and gentlemen, there is no quick evict anymore. Those days are officially over. As a matter of fact, there is more bad news to come. Let's talk about a bill currently on the Senate floor. This is Senate Bill S-3082. The Good Cause Eviction Bill. This bill has been described as a landlord's worst nightmare. Under good cause eviction, if the tenant is paying their rent and is considered a good tenant, a landlord can't evict them. Landlords are still allowed to evict tenants, but only for a good reason. Would you like to hear what is considered good reason? There you can watch the video on Senate Bill S-3082. The Good Cause Eviction Bill, then sign up to become a member of Eagle Eye Solutions Network. Ladies and gentlemen, the eviction landscape right now is geared to make many mom and pop homeowners lose their properties. The American dream of owning and keeping a home just got harder for the mom and pop homeowners. That is why it's in your best interest to have Eagle Eye Solutions working for you. If your property is a 1 to 4 family unit and you have tenants, you need to stay on top of the rules and regulations of the New York Landlord-Tenant Court. Our team of attorneys, process servers and paralegals are here to help you protect your American dream. Give us a call and put us to work for you. The days of being passive is over. No more giving your tenant the benefit of a doubt. You must be resolute in your actions. Giving your tenant time to leave without following the proper protocol will only work to your disadvantage.